Good morning, Counsel.
Good morning, Your Honors. May it please the Court. My name is Thomas Moore, and I represent the City of Springfield and the Springfield Fire Department in its appeal of a Superior Court order invalidating two city ordinances. The ordinances in question were enacted by the Springfield Financial Control Board to address a very narrow class of properties containing outdated master box fire monitoring systems. Specifically, Ordinance 7.13035 requires that approximately 250 of these master box systems be removed and replaced with city-approved radio box monitoring systems no later than December 31st of 2008. The Superior Court's ruling, dated July 28th of 2010, invalidated the ordinances on preemption grounds based on the state building code. This court established the standards for evaluating whether a local law is preempted by an existing state law, requiring a sharp conflict between the local and the state regulation before the provisions, before invalidating the local regulation. Additionally, the court further describes a sharp conflict as appearing where the state law expressly states the intention of the legislature to wholly occupy a field, or in the absence of such express language, where a state law, a local law, the goals of the state law cannot be accomplished in the face of the local law.
Well, on that point, since one of the explicit goals of the building code is to promote uniformity throughout the state and get rid of things that might increase unnecessarily the construction costs, how does one achieve uniformity throughout the state if every city and town can set its own requirement in terms of this fire alarm signaling system? I mean, its own within the parameters of the four that are listed in the building code.
Your Honor, I believe that the City of Springfield's ordinance furthers that uniformity. And I understand Your Honor's point that the city has narrowed the options from 4 to 1, and clearly that's an action that can be limiting in nature. But I believe that the statute and the purpose of the statute specifically state that there should be no more restrictive standards applied. And it's the City of Springfield's contention this morning that no such standard was increased based on the city ordinance, that the identical fire safety standards are still in place from the code. So in fact, the uniform standard still exists. There really was a narrowing of the options to achieve that standard, essentially.
Now, by your logic, if the City of Springfield decided that brick was a safer building material than wood, could it say that brick is one of the many building materials permitted by the building code, but we in Springfield insist that every building be made of brick?
No, Your Honor, the city does not believe that. The city's contention is that this is a very narrow case. This is speaking specifically and only towards fire monitoring systems of this nature.
I understand, but what's the logical distinction? There were 4 alternatives for fire monitoring systems. You said we will permit only one. There may be 4 or more building materials that may be used. Why can't you say we will choose only one?
The city would contend that the fire department within the City of Springfield, through its government, in this case the Financial Control Board, has the authority to decide within its limits which of those 4 would be allowed in the city. And that certainly does not speak to the overall materials and construction elements of the building code, but simply specifically to the fire monitoring requirements as incorporated from the fire code and the National Fire Protection Standards. So the city's contention is that local municipalities are not in the, do not have the authority to tell a contractor which type of brick or mortar to use. However, with the specific life safety element such as fire safety monitoring systems, the city does have authority under its home rule powers to decide which of those life safety systems should be installed for the furtherance of public safety, in furtherance of the goal of the code, as well as in furtherance of the uniformity. Again, that speaks to the Justice's first question.
But uniformity within the city is not statewide uniformity. I mean,
Your Honor, I would again say that the city's belief in this matter is that the uniformity speaks to the safety standard itself, that the code itself speaks to restriction of standards, and that this particular issue goes to that the standard is uniform within the four options.
If you're right and you prevail on this, what would the rule be? We have 300 and some cities and towns in Massachusetts. How could we have uniformity if each could decide on which particular form of fire monitoring equipment to use?
Your Honor, I believe that contractors going to develop projects and do the work that they were hired to do have to be familiar with local rules and regulations, that this particular standard, again, is not changed from the standard that exists within the other three options allowable under the code, that the safety standard is uniform, and that contractors would have to be prepared to be able to install any of those four options, and that if a municipality, through the recommendations of its fire department, taking into account public safety, and in this case, based on the emergency nature of the Finance Control Board, the specific economic impact of such a decision, that those decisions should be held as valid.
Now, can I just ask you a question? Are you saying that somehow the state's four options, according to some standard that is being employed in Springfield, the Springfield has decided one of them is the best?
Your Honor, that is essentially correct. The city has decided that one of the four.
So you're saying that the other three really are objectively not as good?
This is in the fire department's determination. That is correct, Your Honor. Although I would just caveat to that statement that the city does not believe that the other options are not up to the acceptable standards of the code. Certainly, we would concede that all four options are uniform in that standard.
But something is wrong with the code standard then, if the other three are not as good as are not as promoting of public safety as the one that Springfield says must be used.
Your Honor, the city wouldn't argue that there is a defect in the other three systems. It certainly would not advance that argument. The city's argument is simply that, based on the conditions within its municipality, this particular radio box system was the best for response times for public safety and as well as expense over the life of a building. And I know that my brother council and the building board standards and regulations through the Attorney General's office has submitted arguments based on the Superior Court's order saying that the cost of construction is being increased in violation of one of the purposes of the code. However, the section that is cited in the order, I believe it's Chapter 143, Section 95, subsection C, ignores the fact that there is a maintenance requirement included within that purpose as well, that it's not the cost of the construction, but also the maintenance or the life of the building. And the city, in its determination through the control board with the recommendation of the fire department, saw that the system that was going to be required, this radio box system, decreased the cost annually for maintenance, and that over the life of the course of the building, it is in fact a more fiscally responsible option for property owners.
Okay, can I ask you a question about that? I'm trying to understand this. Of course, the ordinance wasn't just prospective. It required everyone in the city to convert to this different system.
That's correct, Your Honor, all applicable properties.
And there obviously there is a construction cost with converting. And then I see in one of the briefs it's not only a construction cost, but then an annual monitoring fee. Who charges that annual monitoring fee for the city-approved radio box?
Your Honor, in the city-approved radio box, that is charged by the Springfield Fire Department, as this is a direct line communication. The other options available under the code involve central monitoring agencies who then, after they are contacted in the event of fire, contact the fire department. And I won't get into the technicalities of these particular systems, as I'm certainly by no means an expert on those technicalities, but from what I've been informed of and from the information that I've read, that the direct monitoring system that the city's requiring significantly cuts down on response times.
And I take it increases the revenue of the city as well. I
would say, Your Honor, it has an effect of increasing the revenue. That is correct.
Everyone has to have one of these.
That would be correct, Your Honor. The The fire department does charge, currently I should say, charges and did charge at the time of the enactment of this ordinance, a fee for monitoring for systems that were not the radio box system, including the system that was installed by St. George's Cathedral in this matter.
Was there a difference in the fee?
There is a difference, Your Honor. The fee, I believe, is $30 for the monitoring for the radio box system, and it is roughly half of that for the monitoring systems that do not include direct transmission to the fire department. However, taken into the total cost of these systems, the property owner who pays for a central monitoring system also pays a fee to that central monitoring agency. So it's not to say that the city has a fee that's double the fee of the other systems. I would say that fee incorporates the fact that all of the monitoring is being done by the city at that point.
Just one follow-up. It's not just this type of system that we're talking about, correct? We're talking about one vendor. Isn't that inconsistent with the goals of the statute?
I believe, speaking to Section 95, subsection C, where it talks about a lack of favoritism given to particular materials, that presents an issue of error within the Superior Court's order as well. And the Court's order, it speaks to that this cost of construction has been increased without the showing that there's a health and safety benefit. However, I think that speaks to the language saying that it must be an unwarranted favoritism within the statute. It includes the language unwarranted.
Isn't what is that issue that it's one company in Holyoke that makes this particular item?
It is a company located in Western Massachusetts that provides the only current product that meets the qualifications of a city-approved radio box. However, it certainly doesn't discourage other products that meet that particular radio box standard from having their products be approved radio boxes. And in this case, there is only one current manufacturer. So that is correct, Your Honor. However, speaking to my previous point about the defect in the Superior Court's order, there was no evidence taken on the actual warrantedness of this favoritism. That at trial, the court cites this an increase in the cost of construction, but ignores that it decreases the cost of the maintenance of the property. And it also doesn't take into account any evidence of the health and safety benefits. In fact, those particular points were argued as germane by my brother counsel, despite the city's contention that all along this is a matter of public safety, and that the city believes that this particular product provides the best opportunity to keep its citizens safe, and the control board acted as such.
So are there two? Go ahead.
And by your logic, if the city were to change its mind and discover that there is a better product, it could then require that new product to be?
Only where warranted, Your Honor, yes.
So, but if it's warranted, you could basically say in 2 or 3 years, we now have a new, better product, which we require all buildings now to have.
I would say that the change out of the system, Your Honor, from the previous order was due to the fact that the master boxes in place in these properties were not up to the code, that they did not meet the standard, that they were antiquated systems. The system that the church in this case installed was a system, not a master box system, but a different system that was up to the building standards of the code. So I can't speak to future legislative action or how the city would choose to decide to handle that issue. But my understanding of how they would move going forward would be that they wouldn't mandate the removal of these boxes, but would require the boxes of the radio box nature to remain in place per the control board's order.
Okay, but whatever Springfield may decide to do, you're asking us to essentially say that it may do that if that were its choice.
In this narrow set of circumstances, that is what the city is contending, Your Honor, yes.
So the building code permits 4 different systems?
Yes, Your Honor.
You've got the master box system. Maybe it's not called that. I don't remember.
I believe that's a terminology of in the fire safety community. I don't believe that's a technical term in the code.
So this radio box system is a different system?
It's one of the 4 options. It is different than a master box system.
And that option, the radio box option, under the state code, can it only be satisfied with this product from this company, or has the city gone a further step and said the only radio box system we would approve is this company's?
The city's determination was that the radio box product that was submitted to the city as a possible product to be used was the best product. So I guess
amongst other radio box products?
My understanding is that it was the best amongst all products. That's correct. So theoretically, there could be a radio.
It is required, isn't it, this particular model?
That is correct, Your Honor.
So it's not only that the city has selected one of 4 different ways of having such a system, but then has selected one vendor for one of the ways.
At this precise moment, that is correct, Your Honor.
All right, thank you very much, sir.
Thank you, Your Honors.
Mr. Chief Justice, members of the court, good morning. My name is John Fitzgibbon, and I represent the St. George Greek Cultural Church in this appeal. Your Honor, this case demonstrates why the uniformity requirements of the state building code are so important. The facts of the case are that St. George put it in a system that complied with the state building code, and as my brother conceded, it's a perfectly safe and acceptable system. And yet they were told that that system could only be used as a secondary system, and that it would have to buy another system from the one vendor that the city of Springfield approved. Clearly, that kind of requirement violates the uniformity and requirements of 143, Section 95, as well as it simply violates the standard of anti-competitiveness in Massachusetts to say that you can only use one vendor. In answer to Justice Cordy's question to my brother, it's my understanding that there are other master boxes, this control system, that are manufactured throughout the United States, but the only city-approved system was this one vendor in Wilbraham. So that clearly seems to be anti-competitive and in violation of 143 Section 95's standard. It says that the code should not provide unwarranted preferential treatment to any particular vendor.
More broadly, though, I mean, it seems to me that looking beyond just the building code, the fire officials in individual cities and towns certainly are in a position to assess a system that would be most efficient and effective in their circumstances. And there are lots of different sizes of cities and towns and lots of different resources or not that they have to respond to fires. Why isn't there sufficient flexibility so long as it's within the 4 approved by the state code to say, for our system, this one works the very best?
Because the Board of Building Regulations has made a determination that the consumer should have a choice of one of the 4.
Is it that the consumer should have a choice, or that these are the 4 that cities and towns should approve? Among one of these 4 should be acceptable.
No, I believe it would be that the consumer has a choice, because there are cost differentials between the 4 systems. Some are more expensive than others. And the city has a remedy. The city can petition under Section 98, the Board of Building Regulations, to restrict it to one particular kind. They didn't apply that section in this case. They never asked for permission. They simply unilaterally adopted the standard. And to allow them to do that would mean that we could have a different standard in Springfield or Agawam or any of the surrounding communities. And it would certainly increase, it seems to me, when you eliminate choice, it certainly increases costs to the consumer.
So you're saying that the city could have, in fact, gotten to the same point had they asked permission to do so?
That's right.
So it's possible then for a municipality to limit the choice.
Well, wouldn't it be, though, that the state building, the Board of Building
Regulations and Standards.
Thank you. They would have to agree.
That's correct.
That, in other words, and they may say, no, we think having that choice available is more important. But the city could certainly apply.
That's correct. Whether or not they would be successful, I don't know, but they certainly could apply. But they didn't do that in this case.
Do you know if that's ever been done? If any fire department in the state or any city or town in the state has petitioned for the limitation of fireboxes?
I do not. I do not know that. But they have other options as well, because the code allows a city to petition for changes in the building code. And you must remember that the board itself is made up of a local fire chief and the state fire marshal. So there is input that they can have on how these regulate, and the state building code is being amended all the time. And so they certainly can have input on the public hearings in that case.
Now, what if there were a master box company which was ridiculously slow in terms of forwarding a call, so that there was a pattern that Springfield noticed that it was taking 20 minutes after the first notice of the fire for them actually to receive notice, and it was becoming a public safety hazard? They can't say that we won't accept this company unless they go to the Board of Building Regulations?
Well, I suppose that they would be able to go after the company if they could show some negligence, but not the standard. In other words, if the master box system itself, they couldn't say that you couldn't use that kind of system, but I suppose they would have some rights to object to a particular vendor if that vendor was not living up to quality standards.
Wouldn't that be a restriction? If it is restricting a particular vendor of otherwise appropriate master boxes?
I don't know that it would be a restriction in the sense of the code, because the code talks about the systems as opposed to the individual vendors. And so I think that presents a different issue. Not that the system is defective, but that the vendor is somehow defective, and that's a different issue.
Do you know whether market forces can play into that kind of an occurrence? Could the insurers of homes that have that kind of a defective response system raise the rates? Do you know if that can happen?
I don't know that can happen, but it seems I would think that would be something that probably would happen, but I do not know it to happen now.
But you could also, I suppose that might be a reason why one might petition to change the code, saying, the vendors for this system just don't do the job.
That's correct.
The system may theoretically be okay, but we don't have adequate number of competent companies to perform.
That's correct. There are methods, as I say, that for the city to seek to limit the choices, but they didn't do that in this case. And to allow a city or town to do it unilaterally, it seems to me, certainly violates what the uniformity standards of the code are all about.
Do you know if there are other cities and towns that have followed the same path as Springfield, that is limited it to one of the 4 options?
I'm informed that there are other communities, and not only are there other communities, they're all sort of on hold waiting the decision in this case, but they're also limited it to one vendor.
The same one?
No, different vendors.
Have those communities petitioned under the building code?
No. They have not. But I'm informed that, for example, I understand that, although it's not in the record, that Lawrence, for example, has done passed a similar ordinance for a particular vendor, not the one in this case.
Does the state have an administrative remedy against a city or town which makes these kinds or imposes these kinds of limitations without first having petitioned?
I'm sorry, I'm not sure I understand.
Does the state itself have any supervisory powers or enforcement powers against cities or towns that have made these kinds of limitations or restrictions on the state building code without having first petitioned for authority to do so?
Well, the Attorney General's office, in the case of towns, when they're approving their bylaws, has uniformly rejected those attempts in towns. For whatever reason, the Attorney General does not required to review city ordinances, and so I'm not aware of any limitation on a city or a city. But on towns, certainly, several towns have attempted to pass such similar ordinances, and the Attorney General has struck those down in almost all the cases. In fact, all the cases that I'm aware of, and those are attached to my brief as well. Some of the decisions. So the Attorney General's office has recognized that this requirement is this exclusivity or limitation is illegal and in violation of the Home Rule Amendment. But as I say, for some reason, the legislature chose for the Attorney Generals did not have to review city ordinances, and so there is no limitation currently, other than the building code itself, and by bringing a suit such as this. So,
does the building code permit, the state building code permit a fire department such as Springfield's to petition against the use of a device manufactured by a particular entity or by a particular company, if it's a defective radio box or a defective master box?
I would think under section, well, I'm not quite sure if that, they certainly have the right to petition the board to make changes, and I would assume that would include the ability to say that this particular kind of system by this manufacturer is not effective or is not required. I'm not aware that that's ever been done, but it certainly would seem to fall within the statute. That's a remedy that they could seek to follow. If there are any other questions, thank you very much.